Summary: licensees owes fiduciary duty to clients and must deal fairly with other parties. The six fiduciary duties are, the acronym we use is CARLOAD. CAR would be confidentiality, A is accounting, R is responsible skill and care, uh, reasonable skills and care. So CAR, what's CAR? C is confidentiality, A is accounting, R is reasonable care. So that's CAR, and then load. So confidentiality, accounting, reasonable skill. Load is loyalty, obedience, LO, and then D is disclosure. So car load, confidentiality, accounting, reasonable skill, loyalty, obedience, and disclosure. Car load. Right? Those are the six fiduciary duties. So how many fiduciary duties do you have? Six. CARLOD. Licensees must disclose in writing any information that materially and adversely affects the consideration paid in a transaction, including information that the seller, lessor, buyer, or lessee may be unable to perform, material defects in the property, the possible existence of any lien or encumbrance. The ADRE requires disclosure if a property is in the vicinity of a public or private airport, military airport, or military facility, military training route. The Lombardo versus Albu case ruled that a buyer's inability to obtain financing was a material fact and must be disclosed to the seller. The case of Development Corporation versus Pima Capital Management shows that an as-is clause does not relieve the seller of the duty to disclose adverse material facts. The Mamas versus Oro Valley Townhouse case decided that failure to immediately disclose material facts once the fact is known is a misrepresentation. The Arachne versus RKP Realty case held listing brokers are not liable for passing along false information from a seller unless the broker knew the information was false. Licensees may not rely on boilerplate language in a contract to immunize them from liability. The case Easton versus Strasburger demonstrates that licensees have a duty to conduct a reasonable inspection of a property and alert buyers to red flags that might indicate problems. The Hill versus Jones case demonstrated that unrepresented sellers have a duty to disclose material defects to buyers. So let's go over the unit quiz. All of the following statements are true except Charlie. So an employment agreement is necessary to create an agency, right? So a client is a person a broker represents. Yes. An employment agreement creates an agency. Yes. Arizona licensee owes fiduciary duties. Yes, there's six fiduciary duties: carload, confidentiality, accounting, reasonable skill, loyalty, obedience, and disclosure. So C says an employment agreement is necessary to create an agency. No. The Rackney versus RKP realty case is important because it clearly shows that alpha licensees may be liable for false statements made in good faith, right? So you really need to know your client's material facts and you put them down on paper. So B says an affidavit of disclosure will suffice as full disclosure by licensee. No. The concept of caveat emptor provides licensees a means of avoiding liability. Square footage of a property is not relevant to a transaction. No. A licensee acting as a dual agent learns that the buyer is having great difficulty qualifying for the loan. The seller has a firm deadline by which the transaction must close in order to start a job in another city. In this situation, the agent, answer is Delta, should disclose the buyer's financial situation to the seller because it is a material fact. So, I mean, think about financing and financial situations. It is considered a material fact if you don't disclose their financial information to the seller, right? The seller needs to know that the buyer is able to close, right? You don't want to string it along, drag it on for months and months and months, and they're just hoping that the buyer can qualify. If the buyer's agent knows up front, they need to tell them. Okay, so from here we're going to go to Unit 8, which talks about Arizona Commissioners Rules, Part 3, Professional Conduct, and Broker Supervision. So some of this you're going to have to, you're going to do some asynchronous learning. We're going to go to the unit quiz. Okay, so a licensee shall expeditiously perform all acts resulting from an agreement. Any delay is prohibited. A licensee shall not allow a controversy with another licensee to jeopardize, delay, or interfere with the transaction. A real estate licensee shall not act in a transaction without presenting a written statement informing the other parties of a present or prospective interest or conflict in the transaction, such as the licensee is acting as a principal, the purchaser or seller is a member of the licensee's immediate family, the purchaser or seller is the licensee's employing broker, or owns or is employed by the licensee's employing broker. The licensee or a member of the licensee immediate family has a financial interest in the transaction other than the licensee's receipt of compensation for the real estate services. A licensee shall not accept compensation from or represent more than one party to a transaction without the prior written consent of all parties. A licensee shall not accept any compensation, including rebates or other consideration for any goods or services provided to a person if the goods or services are related to or result from a real estate transaction without that person's prior written acknowledgement of the compensation. A licensee shall not undertake to provide professional services concerning a type of property or service that is outside the licensee's field of competence. A licensee shall exercise reasonable care to obtain and communicate to the client information material to the client's interest and relevant to the contemplated transaction. A licensee shall not permit or facilitate occupancy in a person's real property by a third party without prior written authorization from the person. Deliver possession prior to closing unless expressly instructed to do so by the owner of the property. A licensee shall recommend to a client that the client seek appropriate counsel regarding the risks of pre-possession or post-possession of a property. Licensees must negotiate through a client's exclusive representative. So indemnification, the dictionary says it's compensation for harm or loss. So if you get, the plaintiff sought indemnification for the cost of the suit against the corporation. It's when you're getting compensated for harm or loss. It's a security against legal liability for one's actions. Whistleblowers protection is indemnification for individuals who are dismissed as a result of reporting a violation. Indemnity. So compensation for damages or loss, or an exemption from liability for damages. The brokerage legal name is Jane Doe, and the DBA name is Typical Phoenix Real Estate Properties. Which name is to appear on all advertising? Answer is Charlie, right? Typical Phoenix Real Estate Properties. So that's the name that's going to appear on all advertising, right? Even though the legal name is Jane Doe, but because you're doing business as DBA, that name has to appear on all the advertising. A salesperson receives an offer to purchase from a buyer, but is unable to contact anyone in the listing office for over 24 hours. The salesperson may answer Charlie. Request written permission from the seller to submit the offer. So request written permission from the seller to submit the offer. So salesperson receives an offer to purchase from a buyer, but is unable to contact anyone in the listing office for over 24 hours. So the salesperson may request written permission from the seller to submit the offer. Can they present the offer to the seller? No. Should they hold the offer until a listing agent can be contacted? No. Can they send the offer to a listing agent by certified mail? No. When a broker has earned a commission, but the seller refuses to pay for no apparent reason, which of the following statements would be incorrect? Answer is alpha. So the broker may place a commission lien on the property in order to postpone the property transfer. That is false, right? The broker can't do that. The broker can't put a commission lien. Can the broker may sue the seller after the close of escrow? Yeah, right. Civil lawsuit, you can do that. Broker may not let a commission dispute interfere with the closing of a transaction. Yes. During a transaction, you cannot have any dispute of a commission to disrupt the transaction flow. D, the broker may later obtain an attachment on the seller's personal assets if a judgment is obtained. Yeah. All right. Regarding advertising of real estate trade names and franchise names, which of the following is true? This one's alpha. Each trade name or franchise office is independently owned and operated, or a similar legend approved by the commissioner must be included in a manner to attract the attention of the public. So B says the franchise name may be omitted, but the brokerage name must appear in the ad. No. The trade name may be omitted. No. The brokerage name may be omitted if there is only one franchisee in the area? No. According to the commissioner's rules, which of the following real estate brokerages would not be required to have a policy and procedures manual? Answer is bravo. So a brokerage with one office, no licensees, and no more than one unlicensed person. Again, brokerage with one office, no licensees, and no more than one unlicensed person. That's the only way. You're not required to have a policy manual because you're pretty much not doing any business, right? You have less than three, I think less than three transactions. You don't need a policy manual. Now, now A says a brokerage with two offices, and you have two or fewer licensees and no assistants. If you have one or more, you need a policy manual, and you also need a sign on your door. C says a brokerage with only one branch office and fewer than three licensees with no unlicensed assistants. Again, you got more than one license. C. Referral brokerage with up to 10 licensees, which closes fewer than three transactions annually. So again, you got 10 licensees. Which of the following is not true? It is Delta, a broker who works from home and has two other licensees, is exempt from having a written policy manual. So this is not true. Why is it not true? It's because they have two other licensees, right? You got one or more, you're not exempt. You need a policy manual, and you also need a sign on your door. Typically, if it's your home residence, that's how that works. A says a broker must establish a system for monitoring compliance with statute rules. True. The ADRE model policy manual may not be used as a company policy manual. That's true. The ADRE model policy manual is just an example to use. A designated broker may use the services of employees to assist in supervising licensees. That's true. A salesperson can buy property listed with his or her broker when the salesperson Delta discloses their intention to the owner in writing. So they need to disclose their intention to the owner in writing, right? So again, this is when a salesperson can buy property listed with his or her broker when the salesperson discloses their intention to the owner in writing. So A says takes title in the name of another person. No. Takes title in the name of the broker. In trust for the salesperson. No. Notifies the real estate department in advance. No. You don't need to notify ADRE for buying or selling property. When acting as a dual agent, a licensee may not disclose Charlie information about either party's motivation to buy or sell. So, say you act as a dual agent, right? You represent the buyer and you represent the seller. Buyer says, why they ask for information about why are they motivated to sell, but you're the dual agent, right? Remember, you have the 6 fiduciary duties, Carla, right? What's the first one? C. What's that? Confidentiality. Confidentiality is you cannot disclose confidential information such as motivation on why they're trying to buy or sell, because you're acting as a dual agent for both of them. Might be different for if you were a single agent representing one party, but as a dual agent, you have even more confidentiality that you have to maintain. So A says material defects in the property. No. The fact that the buyer has been able to qualify for the loan. No. That is a material fact you need to disclose. The fact that the adjacent property is undergoing an eminent domain action. No. A salesperson is offering a free gift certificate as part of a marketing plan. According to Commissioner's rules, which of the following would not be required to be disclosed in the ad? This one's Charlie. Name of the specific store. That's not required to be disclosed in this ad. Name of the specific store. What about the date the offer expires? Yeah. When it starts, when it ends. That's what it needs in the contracts. When does it start? When does it end? What about the terms? Yeah, day start and the terms. What about specific restrictions? Yeah. Which of the following actions is not permissible by a licensed real estate broker? So the answer is Alpha, preparing an appraisal for a property owner. Not permissible for a real estate license. Preparing an appraisal for a property owner. So B says preparing a competitive market analysis. So why is A not permissible? Well, as realtors, we don't do appraisals. We do comparable market analysis, CMA. So we just compare the market. An appraiser does appraisals. So, but a CMA is like an appraisal, but it's not an appraisal. So can we do B? Yeah, we prepare CMAs, competitive market analysis. Call it comps, right? Comps is sometimes what we call it. C, paying a referral fee to an estate broker. Yeah. Place an ad in the newspaper using a telephone other than the company's. Yep. A salesperson receives an offer to purchase from a buyer but is unable to contact anyone in the listing for over 24 hours. The salesperson may, this Charlie, request written permission from the seller to submit the offer. We already went over this one. If a salesperson receives an offer on a property exclusively listed by another broker, he should Delta contact the listing broker to present the offer. So you just typically contact the listing broker, listing agent to present the offer. So should they contact the seller immediately to present the offer? No, because you have an agent. Set an appointment with the seller? No. Have his broker contact the seller to present the offer? Just contact the listing agent. When a broker has earned a commission, but the seller refuses to pay for no apparent reason, which of the following statements would be incorrect? Answer is Alpha. The broker may place a commission lien on the property in order to postpone the property transfer. That is incorrect. Broker cannot do that. Broker has established the following office policy. All listings taken by any salesperson associated with this real estate brokerage must include compensation based on 7% commission. Wow. No lower commission rate is acceptable. If the broker attempts to impose this uniform commission requirement, which of the following statements is true? Answer is Delta. The broker may, as a matter of office policy, legally set the minimum commission rate acceptable for the firm. So if the broker wants to set 7% commission for the company and you're the salesperson working, are you able to help your clients out and lower your commission? No, you are not. If you work for 3%, you work for 3%. If it's a 7%, 4% to the sales, 3%, that's what it is for your company. If your clients are not willing to do that, then you cannot take on the listing. So A says a homeowner may sue the broker for violation of the antitrust laws prohibiting against price fixing. No, because it's an internal company policy. The salesperson associated with the brokerage will not be bound by the requirement and may negotiate any commission rate they choose. No, because you work for your broker. You work in the name of the broker. You represent the broker. You represent the policy manual of the broker. The broker must present the uniform commission policy to the local professional association for approval. No. No, the designated broker who's the ADRE model policy manual may be used as a company policy manual. That's not true. Right? The ADRE model policy manual is just an example um, for you to use to write your own company policy manual. Right? But you can't use it verbatim. A says a broker must supervise all licensees, employees, and the company. Yes. A designated broker has a duty to familiarize licensees with federal, state, and local laws relating to real estate. Yeah. A broker who has no licensees nor employees is exempt from having a written policy manual. Yeah, that's true. All right, next up, we're going to go over Unit 9, property and government rights. So there's some asynchronous learning you're going to do. I'm going to cover the end of the unit topics or the summary and the unit quiz. So overview is property falls into two major categories: personal property and real property. This unit explores the differences between them and emphasizes the basic characteristics of real estate. It also discusses the limitations placed on real estate by the government. Okay, so you're going to do some independent study. I'm going to go over the unit summary and the quiz. So, personal property is movable property and is transferred by a bill of sale. So, say you want to you're selling your house and you want the couch to go with the sale. Can you sell your couch with the house? No, it goes on a separate bill of sale. It's called personal property. So the anything you have in the house, you're like, oh, I want this to go with the house. Personal property on a separate bill of sale. Say I had a client, they wanted to sell their ATV outside their house, and they're like, oh, it's going to go with the house. It's an add-on. No, real estate is only real estate. Anything else other than the walls and the floors, is on a separate bill of sale. Implements, crops, or the right of a tenant farmer to harvest crops are personal property. Right? So if you got crops out on the farm, that's personal property, right? Harvest crops. Trade fixtures are the personal property of a tenant in a leased business site. So say like you're in a barber shop and those seats that are glued onto the floor. That's a trade fixture. That's personal property because it's a leased business site. It'd be different if it was fixed, but it was property house, and that would go with the property because it's bolted in. Real property is immovable and is transferred by deed. So again, the difference between real property and personal property is that it's immovable, right? You cannot move, right? Typically not easy, real property. Personal property, you can move pretty easily. Like couch, you just move it over. Article 10 of Arizona Constitution created state trust land, which is held and managed by the Arizona Land Department. Proceeds from the sale or lease of state trust land are primarily for the benefit of schools, and appurtenance is any right or improvement that is transferred with the land. Tangible appurtenances, including buildings, fences, and perennial plants. Intangible appurtenances, the bundle of rights, include mineral rights, air rights, water rights, and easements. A fixture is an item that retains the characteristics of personal property but is permanently attached to the real property. Mobile and manufactured homes legally become real property when attached to an owner's property by recording an affidavit of fixture. Real estate licensees may list and sell new or used unaffixed manufactured homes and may represent dealers or private owners. The four government limitations on ownership are PEAT, right? P is police power. E is eminent domain. So you got PEAT, police power, eminent domain, PEAT, P-E-T-E. P-E-T is what? Taxation. And E is escheat. So P-E-T-E, police power, eminent domain, police power, eminent domain, taxation, and escheat, right? P-E-T-E. Those are the four government limitations on ownership. PEAT. Police power is the right of the government to enact laws for the health, safety, and welfare of the public. Eminent domain is the right to take private property for public use. So if they're going to take public property, or they're taking private property actually, and they're going to build like a railroad, that's eminent domain. They're taking private property for public use. With compensation to the owner. So they compensate the owner. Now, how much compensation is negotiable? So taxation is the government's right to place a lien against property to operate government institutions. Escheat is the reversion of property to the state when a person dies intestate and has no heirs. That's escheat. So, escheat is, when someone dies. A dedication is a gift of private property to public use. The Bailey versus City of Mesa case held that the government could not take one person's property and give it to another person for private use. The Kelo versus New London case held that taking private property from one party for a redevelopment that would increase the city's tax base and create employment was a public use. So deed, the grantor. So another name for a personal property is chattel. This is true. Buildings and fences are appurtenances. This is true. Riparian rights refer to an owner's rights along the seashore. This is false. Right? Riparian rights do not refer to owners' rights along the seashore. Riparian, it's like river. An affidavit of fixture specifies the methods by which the mobile homes must be physically attached to the land. So this is false, right? An affidavit of fixture specifies the method by which homes does not have to be attached to land. Government rights are the PEAT, right? Police, eminent domain, taxation is cheat. Eminent domain is the process of condemnation. Okay, so let's go to the unit quiz. So the right to light and air, accompanied by the transfer of title ownership to the land, is called a appurtenance, right? Charlie. So again, the right to light and air, accompanied by the transfer of title ownership to the land, is called appurtenance. Is it called fixture? No. Restriction? No. Easement? No. So an appurtenance is the right to light and air, accompanied by the transfer of title ownership. In the case Kelo versus New London, the United States Supreme Court decided that Alpha, creating jobs and raising tax revenue, was a public purpose under eminent domain. So in the case Kelo versus New London, the United States Supreme Court decided that creating jobs and raising tax revenue was a public purpose under eminent domain. So was it blighted areas were not subject to eminent domain proceedings? No. Cities could not take one owner's property and give it to a developers to create jobs? No. Changes in zoning ordinances could be grounds for compensation under eminent domain? No. A buyer's agent is showing a property. During negotiation, the seller agrees to include 2 cords of wood in the purchase price. The buyer's agent should specify it in the contract because it is personal property. So again, a buyer's agent showing a property. During negotiations, the seller agrees to include 2 cords of wood in the purchase price. The buyer's agent should specify in the contract because it is personal property. So again, that'd be handled on a separate bill of sale, but you could still specify it in the contract. A says not include it in the agreement because it was a verbal agreement between the buyer and seller. No. Specified in the contract because it is real property. No. The 2 cords of wood is personal property, right? It's very movable. D, included in the contract because it is a fixture. No, it's not fixture. 2 cords of wood is movable. It's personal property. Real property is immovable. Fixture is immovable. A notice of pending condemnation delivered to a property owner at least 20 days prior to the condemnation action must include all the following except Delta escrow closing statement. So again, a notice of pending condemnation delivered to a property owner at least 20 days prior to the condemnation action must include all the following except. So A, does it include a written offer? Yes. To purchase property? Yeah. Amount of just compensation offered? Yeah. Appraisal showing reasonable comparable properties? Yeah. If the city or state wishes to take property with just compensation, it may acquire title by action based on right of eminent domain, right? Eminent domain is taking that property for the use of the public, right? So like a railroad. So if the city or state wishes to take property with just compensation, it may acquire title by action of eminent domain. So attachment proceedings, no. Adverse possession, no. Police power, no. So it says city is going to take some private property, and they'll with just compensation, and then it's gonna put a railroad right through your personal property house for the public. Eminent domain, huh? All the following items would have bearing on whether an item is considered personal property, except delta, the cost of the item. So damage from removing the item from the property, no. The manner of attachment, no. Any agreement between buyer and seller concerning the item, no. Oh, I'm sorry. I'm sorry. All the following items would have bearing on whether an item is considered personal property, except the cost. Yeah, that's true. So damage from removing the item from the property, yes, that's going to have bearing on an item whether it's considered personal property. So damage from removing, yeah, because personal property is movable, right? Movable. That's personal property, like a couch. You can move it around. So if it's damage, yeah, from removing the item property, that's going to be considered personal property. The manner of the attachment, yeah, that would be considered, right? Is it fixed, not fixed? Any agreement between buyer and seller concerning the item, yeah. The cost item, no. What is required at the time an affidavit of fixture is recorded? This one is bravo. What is required at the time of an affidavit is recorded? The title to the mobile home must be surrendered. So again, what is required at the time an affidavit of fixture is recorded? The title to the mobile home must be surrendered. So, you got to submit your surrender the title, right? You're transferring ownership, so that title has to be surrendered, right? How about the mobile home must have skirts installed? No. County assessor must inspect the property? No. Mobile home must be owner occupied? No. The title, when you record the affidavit at the county recorder's office, the title is transferred to the next person. Which of the following does not fall under police power? So remember, police power, PETE. Answer is Delta. Does not fall under police power, taking land for schools. Right? So they're not going to take land for schools. That police cannot do that. So A, health department and fire department regulations, no. Licensing of real estate agents, no. Zoning ordinances, no. The right of a tenant farmer to harvest crops after the lease has expired is known as what? Alpha emblements. So again, the right of a tenant farmer to harvest crops after the lease has expired is known as emblements. Emblements are those crops, the lease is expired, and they're still farming the crops. That's emblements. Emblements. Is it appurtenances? No. Easements? No. Fructus naturales? That's a one that throws a lot of people off, a lot of students off. How long after the sale of an escheated property does a person who appears as an heir have to claim the proceeds from the sale? Answer is Delta. So 7 years, right? So again, how long after the sale of an escheated property is escheated, someone dies, it needs to be reverted back. Does a person who appears as an heir have to claim the proceeds from the? Yeah, 7 years to do that. Otherwise, it goes back to the state. So 1 year, no. 3 years, no. 5 years, no. You got 7 years. So your grandma dies, you're an heir. You pop up on the 6th year, you're okay. 7 year, you're okay. 8 year, it's already gone. A mobile home that is sited on a rented space in a mobile home park. Delta, it may be listed and sold by a real estate licensee, right? Mobile home that is sited on a rented space in a mobile home park. So I've looked at some of these, and yeah, maybe listed and sold by a real estate license. So A says may not be listed by a real estate licensee. No, a real estate licensee can help sell, buy, um, or help find properties for rent. All that may not be larger than a double wide. No, may be listed but not sold by a real estate licensee. No. The process of acquiring land for public use from an unwilling owner with compensation paid is called condemnation, right? So, eminent domain is, you get private property and use it for public use. But condemnation, you're right, condemn is the process of acquiring land for public use. It's not private properties, land now. So condemnation, think of land for public use from an unwilling owner with compensation paid. Is it confiscation? No. Adverse possession? No. A buyer's agent is showing a property during negotiations. The seller agrees to include two cords of wood in the purchase price. The buyer's agent should. We talked about this specified in the contract because of personal property. All right, next up, we're going to go over Unit 10, which is area and acreage, math, land, development, and zoning. So you're going to do independent study on the first part, and then I will go over the unit summary and the quiz. So this is the ability to perform basic calculations. It's going to be essential for real estate brokers. Especially important is computing area, price per square foot or per acre. This unit contains numerous problems in these areas. In addition, it covers terminology and concepts relating to land, planning, and zoning. So this online unit is divided into three modules. We're going to go over area perimeter math, land development, zoning terminology. So after completing this unit, you'll be able to calculate area of square, rectangular and triangular parcels, calculate perimeter of a parcel, differentiate between offers based on square footage and acreage, calculate area remaining after setbacks are considered, define basic terms relating to land development, and discuss and define various zoning concepts. All right, so we're going to review some key points here. So we're going to review some math formulas relating to area and perimeter. So one thing you need to remember is 1 acre is how much square feet. So 1 acre is 43,560, 43,560 square feet. 1 mile is how long in feet? 1 mile is 5280. 1 mile is 5,280 feet. So if you think about an acre, think about like the Cardinals football stand. That's going to be 43,560 square feet. And 1 mile is 5,000. 1 mile is 5,280 feet, right? So 1 mile is 5,280 feet. 1 acre is 43,560 square feet. A general plan is a long-range governmental or private program to regulate use and development of a property in an orderly manner. A master plan community is a large scale residential plan with many recreational amenities such as parks, golf courses, etc. A natural area, open space is an area or wide easement restricting and preserving the use as a natural environment. The location of underground utilities may be marked by calling 811. So again, if you want to, if you have if you want to locate underground utilities, you can have them marked. Any underground utilities like power lines, just call 811, and they can come out and mark those underground utilities for you. A site plan usually shows a building footprint, parking, drainage, sewer, water, utility lines, lighting, landscaping, all that. The building footprint is area on a site plan that is used for the structure. The building envelope includes all the components that make up the shell or skin of the building. So Arizona 811, it's called Blue Stake. It's when planning to dig in Arizona. The location of underground utilities may be marked by calling 811. Buffer zone is going to be a tract of land between two differently zoned areas. Building envelope, that's going to include all the components that make up the shell or skin of the building, separating the exterior from the interior. It's building envelope. So the building envelope, that's the exterior. Building footprint, right? The area on a site plan that is used for the structure. Down zoning, right? Keyword here, down zoning. This is the change in an area's zoning from a higher to a lower status. It's down zoning, like like business use to residential use, right? As down zoning, such as commercial to residential. Uh, Front footage, right? This is dimension of a parcel along the street. By convention, the first measurement given is the front footage, unless otherwise specified. General plan is going to be a long range overall plan by government to ensure the orderly development and use of property. It's also called a master plan. Master deed. It's going to divide the community into individual lots or parcels for development. Master plan community. It's going to be specific areas with a full variety of retail, commercial, and governmental services available. A virtual self-contained area. Natural area open space is an area of wide easement restricting and preserving the use as a natural environment. Non-conforming use, so like grandfather use, is going to be the use of a site or structure that was legal before a change in zoning and is permitted to continue though it does not comply with the current zoning law. It's called grandfather use. Setbacks. So this is a term used in local zoning ordinances that represents the distance between a lot's boundary line and the improvement. So, for example, you want to build a room addition. I did this. So from the back of your house to the setback line is, where you need firefighters to be able to get to because you have a fire in the back of your house. And you cannot build in that setback boundary. So from your current house to wherever the setback line is, you can build. A site plan is a plan to propose improvements to a parcel. A site plan usually shows a building footprint, parking, drainage, sewer, water, and utility lines, lighting, and landscaping. Variance. A permit is obtained from a local zoning authority, allowing the holder to use property or build a structure in a way that legally violates the zoning ordinance. That's a variance, right? you're getting permission to violate the zoning. Zone is an area set off by municipal authorities for specific use, like residential, commercial, agriculture, industrial, special purposes. Zoning overlay, it's going to create a special zoning district placed over an existing base zone, which allows special use and are provisions in addition to those in the underlying base zone. So let's go over the unit quiz. So after buying a house, the buyer discovers that the eaves of structures is the what? Bravo, building footprint, right? This is the area on a site plan, right? Here's a site plan, and it shows the location of structures. That's the building footprint. Is it the assessor's map? No. General plan? No. Building envelope? No. If a property is required to have a space between it and a nearby wetland, this space is bravo, buffer zone, right? So the space between it and the wetland, that's a buffer zone. Is it a setback zone? No. Is it a deed restriction? No. Is it a brownfield? No. It's a buffer zone. It's the space between the property and the wetland, buffer zone. Height of a triangular parcel is 800 feet, and the base is 450 feet. If the price per square footage is $935, what is the cost of the parcel? It's going to be alpha 168,300. Front footage is the bravo. It's going to be the width of a parcel along the street, right? So width of a parcel along the street. That's what we call the front footage. Width of a parcel along the street. Is it the area of a tract of land? No. The depth of a parcel from the front of the rear, from the front to the rear? No. Perimeter of a parcel of land? No. So the front footage is the width of a parcel along the street. A special zoning district which identifies special uses and or provisions in addition to those in the underlying base zone is a alpha zoning overlay. So zoning overlay, again, is going to be a special zoning district which identifies special uses and or provisions in addition to those in the underlying base zone is a zoning overlay. Is it a non-conformal use? No. Buffer zone? No. Variance? No. Which of the following best situations best illustrates a zoning variance? This one's going to be bravo. Granting permission to build an improvement contrary to the existing zoning. So best illustrates a zoning variance. So granting permission to build an improvement contrary to the existing. So that's when you got a variance. It variants the existing zoning. So you're going to build an improvement, and that improvement contradicts the existing zoning. That's a zoning variance. Right? Is it creating a political zone? No. Is it a use in violation of present zoning laws but permitted because the use was in effect prior to the current zoning? No. Grandfather use? No. Now, grandfather, they just allow it. It's already pre-existing. You're doing a new addition, so it's a variance. So today's world, we're doing a lot of variances because we're breaking existing zonings and improving a lot of things. If an area in which an apartment complex is located is rezoned to allow only single family homes, it is alpha, its use may continue. So again, if an area in which an apartment complex is located is rezoned to allow only single family homes, its use may continue. Bravo says more apartments may be added on. No. The unit may now be sold as a single family residence. No. If a portion is destroyed, it cannot be rebuilt. No. So it's the whole process of rezoning allows it so it can continue to operate. In order to obtain a variance, the owner must demonstrate that bravo, the existing zoning imposes an undue hardship on the property, right? So that's the key here. So you're basically you do that room addition, and now you broke zoning rules, right? And to get a variance, you have to prove that the zoning is causing undue hardship on the property, right? So that's how you would obtain a variance. That's what the owner must demonstrate. So you have undue hardship on the property. Maybe you're getting fines. Maybe you're getting, HOA letters. So A says the current zoning adversely affects the property value. No. C, adjacent property owners have already received similar variances. No. You still got to prove your case each time. Non-conforming use exists in the neighborhood. No. When planning construction to determine if utilities are underground, contact who? Charlie, Arizona 811. So Arizona 811, if you need to know if there's like power lines or any type of utilities that are underground, you call 811 and they'll come out and they'll mark underground utilities. So do you call Arizona Department of Real Estate? No. Do you call police 911? No. Do you call Arizona Power and Sewer? No. Call Arizona 811. They'll come out and look at the utility lines underground. A change in zoning that restricts the use when compared to the former zoning is known as a answer is C, down zoning. So a change in zoning that restricts the uses when compared to the former zoning is a down zoning. So non-conforming, no variance, no zoning overlay. A 1/2 acre parcel is 75 feet wide. How deep is the parcel? Answer is alpha, 290 feet. So we need to do some math for that. An area of land set off by municipal authorities for a specific use is called a Charlie. It's called a zone. An area of land set off by municipal authorities for a specific use is called a zone. Is it a public improvement? No. Subdivision? No. Territory? No. An acre of land is divided into 3 rectangular lots, each with depth of 191 feet. What is the frontage of each lot? Answer is alpha, 76 feet. An area or easement that restricts use and preserves the land in an undeveloped state is a bravo, natural area open space. An area or easement that restricts use and preserves the land in an undeveloped state is a natural area open space. Is it a view easement? No. Master plan area? No. Condominium? No. A building envelope is it's the skin of the structure that separates the interior from the exterior. That's the building envelope, right? It separates the interior from the exterior, right? That's called building envelope. Area on the site plan used for the structure? No. Portion of land that is developed? No. Manner in which a structure is located on the land to take advantage of weather and views? No. When the zoning of a parcel of land is changed from commercial to residential, this change is known as alpha down zoning, right? When the zoning of a parcel of land is changed from commercial to residential, that's down zoning. Is it a use permit? No. Variance? No. Increase zoning? No. The area on a site plan that shows the location of structures is the Bravo building footprint. A change in zoning that restricts the use when compared to the former zone is known as down zoning. Which of the following activities would require neighbor notification? Alpha request for variance. So this is activity that would require neighborhood notification. So you're going to request a variance, and that would require neighborhood notification. So easement by prescription? No. City maintenance? No. City tax collection? No. Which of the following situations best illustrate a zoning variance? Bravo, granting permission to build an improvement contrary to the existing zoning. That's called a zoning variance, right? You're getting a variance. You're violating the current zoning, so you're getting a variance. So B says granting permission. You're going to build an improvement contrary to the existing zoning. So, an area or easement that restricts use and preserves the land in an undeveloped state is a natural area open space. If an area in which an apartment complex is located is rezoned, we talked about this, its use may continue. A large-scale residential development that may include amenities such as parks, lakes, golf courses, and bicycle paths is a master plan community. So a master plan community is going to be that large-scale residential development that may include amenities such as parks, lakes, golf courses, and bicycle paths. Is it a general plan? No. Townhouse development? No. Natural area open space? No. Change in zoning that restricts use when compared to the former zoning. That's down zoning.